Welcome. Thank you all for attending this mediation session. May I ask each of you to introduce yourself? MCSD.
Sir, if you would like, we'll begin since we are the claimant in this matter. My name is Noel the Law. I'm the counsel for the MCSD 6868, and I have to my left Ms. Tu Much Money, who is the chairman of the MCSD.
You may call me Money.
Okay, Money.
Yes. Good morning, sir. My name is Court Champion, and I represent the developer, Tauke Conglomerate.
Yes.
The managing director, no less, is here with us today. He's seated on my right. Mr. Taller Buildings.
Taller is fine. I guess I don't need my top hat, right? So, why don't we just be pleasant to the mediator and show some? Yes, thank you.
Thank you. My name is Sechu Meng, and I'm your mediator today. As a mediator, I am neutral, I'm impartial, certainly not a judge, not an arbitrator. And bear in mind, I do not make any findings. You have to own the solution that we're trying to seek today. My role actually is to bring the both parties together so you can talk directly to each other. So I ask you to be patient, keep a positive mind, speak freely. What is spoken today is confidential and certainly without prejudice, which means that whatever you say today cannot be used against you if, unfortunately, which I hope not to be the case, there is no settlement. I would like to check that both parties are here voluntarily and have full authority to agree to any settlement.
I go first. Definitely, I'm here voluntarily and I have very full authority.
As for me, it was my lawyer who convinced me to come here, right? So he's done a brilliant job, great idea, saves me the hassle of fighting with these people, right? So definitely voluntarily. If I wasn't voluntarily here, would I be dressed this way? I need to showcase what kind of a developer I am, right? You need to appreciate that at the end of the day.
You have a sense of fine dressing.
Thank you, sir.
And
Thank you.
sir, definitely he is a man of authority.
Yes, I do have the authority to decide because it's all me, myself, and I. That's all.
Okay, I'm going to go on to the next point, which sometimes I find it a bit embarrassing to mention it, but I'll still bring it up. I hope the legal counsels on both sides have not advised your clients that each of you have a cast iron case and not to move from the present position. Because if you do that, then we're not going to have any settlement today. All right?
Well, we certainly know what our case is, and I assume that my learned friend also knows what my case is because we set it up earlier. I'm just interested in what their position is.
Sir, they've only given you a 500-page mediation case statement. I've given you 50,000 pages. I'm sure we will prevail.
Our case is iron-tight, brilliant. So, I don't know what, you need to know about those details.
Thank you. I also like to ask parties to agree to the following ground rules. There should be no name calling.
That's going to be difficult. We'll try.
And parties must behave respectfully towards each other. And when one is speaking, the other should not interrupt. All right?
Oh, you need to repeat that to her again, because she has difficulty controlling all
I think she has heard it correctly.
Yeah.
You're doing well.
Now, before I
You're doing
begin,
well.
on the use of handphones, please keep it on a silent mode. If you have to make a call to your office to check up on facts, you may do so, but please step out and go across to the breakout room, which has been assigned to each of you. All right? Okay. I would now like to begin by asking each of you to tell us briefly what this matter means to you. If the developer does not mind, may I ask the MCSD begin?
my very brilliant lawyer on my right can begin for me, because I have very full authority, but he has very full brains.
So let me just begin with a quick flesh out of what our problem is with the developer. We set it out in full in the opening statement, but let me briefly take you through what's the problem we have. We have a situation where we have actually incurred $250,000 to replace glass panels that have fallen. Now these glass panels are balcony balustrades. And the problem is that you have a situation whereby it is dangerous. Not just from the falling glass panels, but from the fact that you cannot leave these balconies empty without protection. There's always the danger that young children may fall out of them. So we fixed the problem because the developer was not responding. And they actually haven't reacted until the day we decided to sue them. We haven't gone further with that action because we've agreed to mediate, which I would like to express my client and we're grateful for that. But we think that our concerns need to be addressed. So we've incurred $250,000 to deal with the most immediate defects. We have an expert report that says that given what has happened, there is a danger that the remaining 140 glass panels that have been installed will have similar problems. They may not surface now, but they will manifest later on. And we have a figure of $1.7 million as the cost of doing that. And that's not a small sum. That's something that we look to the developer to deal with, because that's
your mediation case statement, you said it's 1.75 million, not 1.7.
I'm sorry, give or take. Thank you for that. Quite apart from that, we've got another notable defect, and that is the swimming pool, the tiles are popping up. It's been less than a year. Being a construction lawyer, I know your defect liability period is at least 18 months these days. That's way too early for any defect of that major nature to be showing up. There are a lot of other stuff that's in the expert report. I wouldn't take you through it, but these are the key defects. Now, I'm going to also ask the representative of my client to just say a few words as to why they are here today. I mean, that's just the legal case, but why they are here today, I'm going to ask Ms. Mani to say a few words.
So, it is a miracle that no one has been injured yet. But I nearly was injured. I was swimming in a pool and pop, 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 the tiles pop up. How can? I was dressed so nicely. And then, leaning on my balcony, looking very fine, I nearly fell out again. How can? It is a miracle. This is a very atas, high-class development. We are very atas, high-class occupants. How to live like that? It is terrible.
Do you always dress up for swimming pool? For swimming?
Isn't that how everybody swims? You must look good.
Seriously, the dressing up has got nothing to do with the pool and popping up. It's probably the weight.
See? He interrupts again. Where are the ground rules?
Okay, you finished? Can I ask the developer to respond, please?
Sir, I think it's important for my learned friend and his client to read our 50,000 pages of evidence. Exactly. Whatever they have said, we categorically reject because they are untrue. My learned friend talks about coming here, and when corrected on the quantum that he has exaggerated in the claim, he says, give or take 1.7 million. We feel strongly they are here just to take. No one has been injured. So let's not dramatize the situation in a bid to ask for more compensation. And in fact, we put it down to the MCST's failure to properly maintain the premises. And that would definitely accelerate defects. So I think Mr. Taller Buildings should have his say. He is a very knowledgeable person, having multiple degrees in quantity surveying, the law, engineering, architectural, and so on. Did I miss out anything? You have a PhD in communications too, right?
Exactly.
Yes. So
let's take it from there.
yes.
First point, the expert report. Nothing wrong with the design or the specifications. It's so clear. Which part of that do you not understand? Just dressing up and leaning against the glass is not going to help all of that. Right? Point number one. Point number two, do you know how buildings are built? do you know that we engage contractors, and there's a main contractor who's independent of whatever I do, and who can be responsible for it? I don't know whether you've considered all of that. The last thing is this. Where is the evidence? Do you have a crystal ball or something that you can tell that there are another 140 are going to fall off? How's that? How do you figure that out? I don't understand. So mediator, they're not being reasonable in whatever they're saying. So please
We'll
consider
deal with that. We'll deal with that.
All right? Okay. I hope you do deal with it, because her antics will take us through till probably past midnight today if we don't reel her in.
I have a way of dealing with that.
You
Don't
see,
worry.
he insult me again all the time. That's why I don't know how we
Okay,
can
cool down,
mediate.
cool down. Don't interrupt each other.
Mr. Sia, I'm not going to interrupt, but if they finish, I have a word or two about them.
No, nobody said.
Unless it's on the subject matter, if it's on personal, then I'm not interested.
Just quickly on the subject matter. So, you obviously know that we've got two separate expert reports. We have a dispute, right? I don't see where we're going to go with this if we are just going to take a position. Our position is quite clear. If you've got 20 tiles falling down in a very period of 6 months, it's a matter of time. Tiles are not supposed to fall down. Buildings are supposed to last for 30, 40 years, right?
Not the tiles, the panels, you mean?
Or the panels have fallen off, haven't they? Right? The tiles, sorry. I'm not talking about the swimming pool tiles. I'm talking about the
They
glass
don't know
panels.
their facts.
They don't fall down. So, fine. If you want to take this to court, we can. But I would seriously ask you to consider, look, things happen. It's a fact. Belittling our experts not going to do you any good. Now, if you want to go ahead, we can. Now, if you want to talk about your main contractor, that it's done by your main contractor, we seriously ask whether, how do you engage the main contractor? How do you get a guy to build buildings in the way you've built?
I suggest we don't go into a protracted discussion.
Very good, sir. You lead the way.
All right. Ms. Tu, will you start the...
You can call me Money.
okay.
Face.
No name calling, please.
Sorry.
So we must definitely discuss the replacement of all the glass panels. Then we must discuss all the rectifications for all the other defects. Because it's a very atas condominium. So must have good fixtures. Anything else I
So
miss?
just to repeat, it's the replacement of all the glass panels and the repair of all the defects.
Yes. Anything else?
No, I
Maybe
think
a new
broadly those are the two areas of concern at this point in time.
Right?
So
But
the
you gave a
parent,
very huge mediation case statements for me to read. And you only have 2 items in it.
Well, a lot of it was the expert report, sir.
I see, okay.
And I said, at this point in time, we're not prepared to talk. We don't want to talk about the minor effects. If they're not prepared to come to some arrangement with respect to the 2 major ones,
But it's good that you concentrate on these 2.
we thought so too as well.
Okay. Mr. Buildings?
so I think we must confine ourselves to whatever is in the mediation case statement. It's just the glass panels and this ridiculous swimming pool tiles. And Mr. Bleedings has something to say to
I
you.
just want to know, how much is it costing? How did you come up with those figures? It's not clear, you've got loads of documents, but I can't tell exactly what the exact figures are for replacing the glass or the rest of the stuff. So I need to know exact figures, right? And then the cost of rectification of the other defects. I don't have details. They have an expert there, so surely the expert must be able to put those figures down, right? It's not brain surgery, it's simple.
So we're happy to discuss that. It's in
Okay.
there, the papers, but we can help. We can discuss this.
Just to a point I'd like to make, Mr. Building. It's good to hear that you are talking about trying to settle and looking at costs.
That's all.
I was a bit concerned when I read your case statement. You were going to rely on the independent contractor defense, which will make things difficult.
Well, that's a legal point, but, we are here in mediation, and my lawyer has explained to me at length that some of these issues must be put aside, right? But personalities and ego, I don't know about that. But, I think we can come to some consensus, but the cost cannot be the amounts, ridiculous amounts that she's asking for.
Okay, fine. I think I've heard from both sides now. We're quite clear on the agenda. What
So
I
these are
will
like-
proceed on, as I mentioned earlier, is to have the first joint session with both parties. Okay? Ms. Tu, will you begin?
I will let my lawyer lead because he's a very good leader.
He's good at everything.
That's why he went for him and not you.
Oh,
I'm sorry.
no, it's all
You
right.
done?
Yes, I'm done. Go ahead, please.
So, sir, I alluded to it earlier, and I'm just going to refer you to maybe page 205 of the statement. You will see that there is the expert report. And in terms of the replacement of glass panel, if I could just sum up the 50-page report, it's just quite simple, right? At the end of the day, we are asking, 20 panels had to be replaced. We're asking for $250,000. Why it had to be replaced is there. In terms of the cost, you see the quotation that's referred to in the expert report. We had to pay $250,000. Now that works out to be
You've actually paid up.
we paid. We had to. It has, if you remember, sir, this was in June. We had to get it fixed. June was when we decided to sue. We already fixed it before June. And obviously because it was dangerous, we had to. And we fixed it and paid it. That's why we're suing.
We cannot wait. They kept ignoring us. Ignore. Of course, we have to pay first.
Hey, sorry.
cannot complain.
I did not ignore you, okay? You just didn't give me the time of the day. So
I gave you more than enough time. You can't expect me to wait long. I don't know where you come from, Mr. Bleeding, but cannot be so unreasonable.
you asked for 1 day, answer you in 1 day. This is not a quickie, you know. You know, we need time to figure out what exactly you're asking for before we can put it down.
What did you just say?
Whatever,
Mr. Mediator,
whatever.
I complain.
Now you
He
see
was
that
just
the
putting across the point. He wasn't given
Sufficient
appropriate
time.
time frame to look and investigate the defects that you alleged.
Maybe we need to add this as an agenda to talk about time, because as far as I know, the documents are quite clear. Even before I was engaged, my client wrote to you in, I think it was November. They got a no response. In January, they got no response. I think the 1 day notice you're talking about is when we told you if you don't actually pay the $250,000 and come back with a proposal for damages, we were going to sue.
Sorry, I don't understand. I thought we already set the agenda and these are the only 2 items. You know, and the mediator has told us that, you know, it's good that to see that we are narrowing it
So
down.
we're not going to talk
are you
about
gonna add
that,
on?
right? We're not going to talk that.
I mean, she started it. She started it with
So
the
as
issue.
far as the cost is concerned,
See, again, she start this, she start that. He's got no excuse. He's just calling me names all the time. I thought there were some ground rules.
Well, I'm not calling you the big name, B. Right, that's fine.
Oh,
That's good enough.
he just said
right?
it again.
Let's
Mr.
focus
Mediator,
on
I
the agenda.
complain.
Let's just focus on the agenda.
Cool down, Ms. Tu. I think, Mr. Building, I'd like to address something here. TOP was in February 2018. And in November of the same year, the first tower fell, and they gave you notice. January, March 2019, it happened, and in May 2019, a total of 20 panels had fallen off by then. Right, Mr. Building? No, actually, Mr. Building, I noticed in the report that you have completed several high-end buildings. And you have built up a fine reputation in the marketplace. Fine dress sense as well. Certainly you're a man of distinction. Don't you think you should not use rude terms on Miss Tu?
Sir, my client is well aware, and he will try to keep himself a little bit in control. He will try.
A little bit?
Yes, sir.
Yes.
Total control.
Yes,
Okay,
sir.
I'm not going to dwell
Well
on it.
noted.
I'm going to move on, okay?
so just come very quickly. Let me finish the points we want to discuss. Number one, if we want the glass panels to be replaced, I will address the concerns of the developer. The cost we are looking at for the one replaced 20 pieces is $250,000. For the balance 140, it's times 12,500 per panel. That's $1.75 million. And as far as the other defects are concerned, the cost of the swimming pool, we've got a quote for 150,000 to fix the popping tiles. For the balance of the defects, it works out to be about $500,000. So those are the figures we're talking about.
Okay, before I move on to the developer, I just want to summarize your case. Okay? MCST has spent $250,000.
That's right.
Which is 20 panels by $12,500 per panel.
That's correct.
You also want the 140 panels, the remaining 140 panels, to be replaced at 12,500. That equates to 1.75 million.
That's right. Right?
Yes.
Swimming pool at 150,000. The other defects at 50,000, at 500,000. Sorry. So the total is 2.65 million.
Yes, sir. The reason why we're not putting too much emphasis today on the defects of $500,000 because they consist of about 400 small items. And we really want to see whether they want to talk about the big items before we deal with that.
I see a difficulty in that because in your mediation case statement, the 500,000 was in very general description.
It was. And for a specific reason. We had 300 over items there. So all very, very small items. But I think if we're going to move forward, we need to talk about these two, as Ms. Mani said, we need to talk about the glass panels, we need to talk about the swimming pool.
Sure. Okay, are you complete? All right. Mr.
Sir,
Building?
if I may, I would just like to highlight to the MCST and Council on two important legal points. The first is my learned friend lost to me in case XYZ, which confirms that the developer client has a defense of independent contractor. They are not liable for acts of the main contractor, but he is here in goodwill today and trying to keep himself totally in control. The second point I wish to make is that the claims that they have alleged in the mediation case statement are exaggerated. They amount to betterment. It is better than the original luxurious quality that was already promised. For instance, sir, their panels cost a ridiculous amount of money. Our glass panels were supplied at $3,000 per piece from the best manufacturer that we could source at that point in time. And we say the number cannot be bigger than $3,000 per panel. And of the panels that have fallen, they have replaced them, but they now exaggerate, they need to replace everything else. So the point, sir, is no losses have actually been incurred other than the 250,000 that they talk about. And Mr. Taller Buildings has something that's far more important to bring to your attention.
Actually, the quality, the cost of the glass panel was only $3,000. Even if you take 20 panels and you're going to blame us for it, that's $60,000. It's nowhere near the $250,000. And $12,500 for a panel that's of a different quality, not for the similar to the original quality, that's really unreasonable. And that's why we said that the only issue is how did you come up with these figures? You know, if we can narrow that down, we can get somewhere with this, right? But if they're not going to willing to listen to that, then we're going to have a problem. But essentially, this is what it is. And as far as the swimming pool is concerned, you know, they've only got one quote so far. No way can we then tell whether or not the cost of the quote is reasonable. So we need to work that out. So exactly the points that we put out on the agenda, that's what we need to deal with. You know, so if we can focus on that, we can get somewhere with this.
We are focused on that, just that we don't have an agreement.
Okay. So before I end this session, just to summarize the points you've made, basically, the original quote when you built it was $3,000 per panel.
Exactly.
And you think that 12,500 is excessive.
Brilliant.
I'm brilliant?
Yes, sir.
The best mediator we've seen.
And you're prepared to prepare the swimming pools and other defects, but you are not happy that they have no, they got only a single quotation according from the case statement. Is it true?
Awesome.
Well, I think I'm doing a good job actually. Okay, all set, all right. we've come to the end of this first joint session. I would like now to move into the private session, which I mentioned earlier. Now, just before I go into it, for the private session, I'll be seeing each of you one at a time, while the other party move out to one of the breakout rooms opposite this chamber. And during this private session, you can explain to me all the problems you have. Importantly, is how do you want to resolve it? Okay? So, it's quite late now actually. I suggest we take a break. And after the break, with your permission, I'd like to start off with the MCST. Is that all right?
Don't need my permission. You need that much time with her, because it's going to take
But
a long
of course
time to
you should
figure it
start
out.
with me. You should always start
Sir,
with me.
given that we expect it will take a long time with you, can we help ourselves to the snacks the SMC has provided
Oh, please.
outside?
Yeah.
Thank you.
The snacks are provided in the
Yes.
breakout rooms. Please help
Thank
us
you.
do it.
Thank you.
So we've come to the end of this first joint session. Ms. Tu, in this private session, I want to reiterate that whatever is shared here will be kept PNC, unless permission has been given by you for me to share with the other party. Feel free to share with me any concerns you have. Let me address a few points. Reading your mediation case statement and the points you made earlier, you may need to review the cost per panel. I think if you do a market comparison, it is indeed on a very, very high side. The other point I think you need to address is that you have only obtained a single quote for the swimming pool repair and the repair of the other defects. Can you give this some thought as you move forward?
So the second point again, what was the second point that you want us to address?
You have only obtained a single quote for the swimming pool repairs and the repairs of the other defects.
I see. Okay.
Yeah.
Mr. Maybe you want to explain to the mediator what's the MCSE's position in terms of the cost of the glass panels.
So as chairperson of the MCST, safety is paramount. I really must look after my residents, I must look after all the visitors. We cannot take any risk, you see. And all the panels, every one of them, non-negotiable. Yeah? Privately, I say to you, non-negotiable. Because, that man, he hired this main contractor. I don't know where he found that main contractor. Main contractor, no money. Not like me. Me, plenty of money. Main contractor, no money, no assets. And the subcontractor, let me tell you, the subcontractor who supplied the panels, bust. So I don't know where that man finds all these other men. If they had found ladies, maybe would have been a bit more helpful, but, well, that's how it is. Went bust in 2018, the subcontractor, even before the first glass panel fell. And then I told my very brilliant, helpful, wonderful, handsome lawyer here that our sinking fund, very sinking feeling. Our sinking fund does not have much money. We don't have enough money to pay. So we need the developer to pay. No sinking fund, need developer. But, well, our lawyers have told us that, this independent contractor defense he keeps talking about, it is not easy and that, well, maybe we shouldn't have replaced with $12,500 panels. But, I wanted the estate to look very nice So, a bit more shiny, So I didn't go for the cheaper one. I went for the more expensive ones. But we were desperate. That man kept ignoring me. kept ignoring my calls, kept ignoring all my requests to help. So,
For over a year.
yeah, ignore me over a year. I tell you, some people are. So, I'm hoping that if they can pay us 160,000 for the panels, roughly about 8,000 per panel, our sinking fund can cover the 90,000. Because our sinking fund has about this $90,000. We're happy for the remaining 140 panels. Yeah, they can go for the cheaper option. I heard them talking about 3,000. I don't know how they can get 3,000.
That's the original price they paid.
That's what he says.
We don't know.
We don't know.
We
right?
don't know. We
Yeah.
don't know whether it's 3,000. All we know is that we got quotes. Yes, perhaps the MCSC spent a bit more because they wanted better quality. But you have to understand that we were dealing with 20 pieces. I don't know what as a developer, so you can understand they buy a lot. And obviously there's bulk. We don't have the kind of advantage. So, we hope you understand why it's not completely unreasonable that we are paid 12,500 per piece because we didn't have a choice.
We didn't know.
Their concern is that if you then proceed to replace the remaining 140 panels, then I think that's going to be very expensive for them.
But, if he can really source good quality panels, then maybe we are not so concerned about the
Yeah, we
cost.
should be concerned as well because
Must be safe. Yeah,
no,
must be
if
good
they
quality.
replace the panels, they provide the panels and replace. We can't be bothered. Whether it's even $1 or it's 3,000 or 1,000, we don't care as long as they replace the panels.
Fix the problem. Fix the problem because safety is paramount. And then the swimming pool tiles, that's really so ugly, I cannot take ugliness. It's got to be rectified. Our sinking fund, again, no money. So he really has to do something about it. These two really are the most important to us. I've discussed with my lawyer, right? And maybe the other things we can, think about it, but these two things are really
Other
important.
things, the other defects you mentioned.
Yeah, the other defects. The 300-400 defects amounting to $500,000. Yeah.
So in terms of the swimming pool, you saw the photographs, right? The tiles have popped up. If you have people swimming in the swimming pool in that condition, they could get their feet cut. So, we haven't said this, but, there is an obvious problem. Let me just talk about the main contractor. And I know the law.
You're born
My
for the law,
little
actually.
friend can brag all about the case, that one case I lost to him. Okay? Well, let's just consider this. We know who the main contractor is. We know the main contractor doesn't have any money. And I'm asking myself this question. You are a luxury developer and you engage a company that has no track record, that's got no assets. There's a bit more to that. Right? Now, I haven't done any investigation because as far as the company has no money, right, we're not going after that. But I'm going to really, really ask myself this question at the end of the day about the validity or the strength of the arguments of this independent contractor. Now, so I think in terms of what we want, sir, let's be candid. You've heard my client say, sinking fund got no money. Can you imagine how they're going to pay my fees?
Can we talk about that later?
Yeah, we can talk about it later, but look, listen, let's call a speed, all right? We have to think about this. That's why we're keen on mediation. It's a bit obvious. You just said it yourself. We've got 90 grand.
Okay, it's getting quite late. So,
Sir, but let's be clear. We don't want you to tell them too much about our financial position.
Yeah.
That's
Sure,
absolute
Don't
no-go.
say that. Don't say that. Yeah. Just say I got too
no,
much
like,
money.
like I said, everything remains confidential at this stage. So just to summarize your case, basically, based on your submissions and discussions, you want all the panels to be replaced.
The expert, that's not what we want, sir. The expert says, just on a 20 falling, nothing is said.
But you're agreeing to the expert, basically.
Yes.
So I'll put it down in my notes that all the panels have to be replaced. And that perhaps you would consider the 20 panels to be reimbursed at $8,000 per panel.
Can we do 8? Are you comfortable with that?
Yeah, because
Instead of the
sinking fund
12,500 that you paid for?
90,000, can, but I don't want you to tell them that straight away, I want to know what they offer.
Okay.
Yeah.
I think that's a fair request. They are saying it's $3,000. And
So that makes it 160,000 for this item, right? Then for the remaining 140 panels, to be reimbursed at $3,000 per panel. The same price they paid.
So long
when
as
built.
they replace, right? Then they can say whatever price it is, but they must replace the remaining 140.
Okay.
Now they can go and source for it, but so long as quality good, look good, I agree.
So with these main repairs, then you take into consideration the repairs of the pools and the other defects.
They have to fix the pool.
Yeah.
Very
At,
ugly.
at their own
must
cost.
fix. At their own cost, yeah. They
Okay.
Go and fix it, yeah.
I make it out, these are the main points, all right?
Can.
I suggest now you make your way to your own breakout room, whilst I'll call the developers back into the room, all
The
right?
snack must pay or not, or can just eat.
Sorry, I
The
know,
snakes
we've
are
already paid
provided-
for it.
They're provided
Eat
free
more,
of charge.
eat more, okay. Thank you, sir,
Although
thank
they
you,
say free
sir.
of charge is in the fees anyway, so
Oh, okay.
you better eat up.
We better dabao some.
Thank you, sir. We'll come back later. Thank you.
Thank you, yeah.
Mediator, sir, did you need my hard hat?
No. She's a very gentle lady.
Yes, right. I believe that.
So we commend you for your patience. It's been 5 hours in the private caucus. And Mr. Taller Buildings Forbes' interview for the next billionaire of Singapore is being delayed. But we're here in good faith.
Yeah.
So, sir, very quickly, 2 points. Mr. MCST and his client does not understand the emphasis that we have legally. We have a good legal defense of independent contractor. My client, the developer, has no liability at all. It is still the defects liability period. Yet they have gone ahead to replace the 20 glass panels themselves and now put forward a bill of $250,000 to Tauke conglomerate. That's unreasonable.
Okay, before you proceed further, can I address certain issues? You have indicated earlier on your willingness to compensate the MCST, right?
We must
Then-
correct you, sir. We said it's
let me
3,000.
finish. As a matter of curiosity, why are you not involving your contractor in today's discussion?
That's another story, sir.
Because you mentioned in the mediation case statement, you're going to rely on the independent contractor defense, but you have gone away from it, I noticed.
Main contractor related to us.
You can
know,
tell
left
him the
hand-
truth.
left
It's a
hand
private
going-
session.
Left hand going into right hand, going into the back hand and front end. Right? So I really don't want to get them into trouble.
The money flows everywhere. Huh?
Exactly. You know, upstream, downstream, we don't know. But the big picture is this: I don't want the main contractor, my related company, to get into any trouble, right? And that's part of the reason why I agreed when he told me, my lawyer knows all these details, and he said the best way to sort this matter out without getting it out in the open is if we mediate. And he also informed me that you need to make some balance. So I'm willing to make some balance, but I don't want you to share that with them yet, right? We needed to take our position right when we started the way we did it, but we are going to take some step back. We're about to launch 2 high-end projects, right? So all of these are really things that are in the back of my mind, right? So we hinted to the fact that we had this, it was $3,000.
The same price you paid for.
Exactly, right? I mean, logically speaking, I can replace the 20 for that price, right? So I need to consider that, and the 12,000 is a ridiculous amount. 12,500 is a ridiculous amount. We don't want to go anywhere near that, right? So this last part about moving from about 3,000, I'm willing to do that, right? But the rest of it, I really need to protect
What about the 20 panels they paid?
Exactly, on that one, right? What I'm thinking of is that I'm willing to make some adjustment, right? Because I want to make sure that my main contractor doesn't get into trouble. I need to make sure my 2 launches are up and running. My billionaire status is up and coming. I need to look at all of that. So the 20, some form of adjustment needs to be made, right? Now the remaining 140, surely if we if we decide that we're going to come to some arrangement, let us do it. We will do it right. We will do it at the price that's reasonable.
So you will undertake the complete repairs?
Wait. We still have a long day to go. You know, we've had other mediations that have gone into 2 a.m., 3 a.m. We're nowhere near that yet.
Well,
right?
we
So
have spent 5 hours.
that's
already.
with her. We've taken what, half an hour so far? All right, and I'm telling you, some of the things you can tell her, but the fact about my main contractor, the projects that are coming on board, let's not discuss that. But maybe for the 20 ones that they've paid 12,500, we can come to some reasonable sum. And if we are going to do the 140, then we can talk about that. Right? At the moment, that's the status I'd like to leave it at. Anything else?
Certainly. And I think, sir, it's important not to enrich the MCSD's sinking fund. So we'll only address what they've actually spent so far. They were misguided in overspending. They did not get proper quotations. We've looked into the documentation.
But because you're delayed by over a year.
Well, sir, we are in the defects liability period. The main contractor is around and willing to do any genuine rectification works required.
I'll put one more thing in. You can you tell them that the swimming pool I'll deal with. You know, the only reasons the tiles popped is because the way she was dressed. Even the tiles, popped,
But, Mr. Building, we need to make clear that
Nothing else.
this wild suggestion of other defects should be off the table.
No other
It's
defects.
just the glass
The oth-
panels and the tiles, correct, sir?
The other defect is her brain cells. That's all is defective, nothing else, but we don't need to share that. The swimming pool, we'll do something about it, all right? Just so that, it doesn't have to pop whenever she appears again, all right?
Okay, it's getting quite late, so I'm not going to delay it too much longer. I'll just summarize the main points of your case. You're prepared to replace all the glass panels at $3,000 per panel. And for the swimming pool and defects, you will undertake to do it at your own cost.
Yes.
And for the 20 panels, they already paid for the money, paid. So you consider to compensate them something.
Something, not all of it,
Okay.
all right? Those three things, those 3 points, you brilliantly summarized it, you can take it to them. But the rest of it, PNC.
Okay, at this juncture, I would like to bring the MCSD back into the room because I think the gap is closing. Shall I?
Yep.
If you feel that's right, sir.
Yep.
Okay.
And as long as we don't spend another 5 hours here.
Yeah.
Okay. Because then I'm going to throw my hard hat at her.
All right.
All right?
So I understand you called for us.
Yes, we did.
Thank you.
Now, this will be the second joint session. And at the beginning of the mediation, I did say that I will only have this session, the second session, when I see there's a possibility of meeting of minds of a settlement. To help all of you along, because I can see a very bright light at the end of the tunnel. So what I've done is to lock the doors and throw away all the keys.
But we're not changing the lights, sir.
Also, I'll let you know there'll be no biological breaks
Oh, shit.
until the agreement is signed. Is that okay with both of you?
Our bladders will prevail.
We can hold it in.
My bladder bigger than his.
Sounds a little extreme, but it's the first time for everything. Yeah, I think I'll give it a try.
I must encourage you all to settle that, okay? Not to worry, SMC staff, they're all on standby. And they're quite used to working very late to help us to achieve a settlement. Since we are quite, like I said to you, when I'll call for this session only when I feel that there is a good chance of a meeting of minds to resolve. Maybe I would like to throw open the discussions to both of you to conclude on the glass panel and the repairs. All right? Who would like to start first? MCSD?
No, we start. I'll tell you what, the 20 glass panels, I'll give you 4,000 each. Because we did it at cost at 3,000.
I don't know where you get your cost, but it's nowhere close to ours. We want 8,000, right?
No, okay, let's share, okay? I think, speaking on behalf of my client, and again, because it's without prejudice, maybe we were a little bit too quick to accept the quotation from the contractor that eventually replaced 20 tiles. Okay, but I think you need to understand that we are in a situation where we needed to fix it really quick. And look, for 20 tiles, 20 glass panels, we can't get the same pricing as you get, right? No, I know, let's take it at face value, you get it at $3,000 a piece. We can't get it at $3,000, we can't get it at $4,000, right? There's no way. We had to buy this literally at the retail price of 20 pieces. And as developers, I'm sure you agree that you're in a better position commercially to get the bulk discounts from your suppliers and contractors. We don't have that.
We're
And you
also
guys
in a
want to
better
replace-
position commercially to take this all the way. We have deep pockets, not like the MCST. But he's willing to be reasonable.
Yes, I'm just saying, if you're going to be reasonable, then be reasonable and think about these other issues. If you were in your own condo and you had only 20 pieces to replace, we didn't replace the 140, we replaced the 160, we only replaced 20.
He stays
If
in
you
a
were not a
good-class
developer-
bungalow. He doesn't stay in a condominium.
Even good class
Okay.
bungalow thing can fall down.
So, really, the
No,
situation
nothing pops in the bungalow.
Because
Because
I
we don't
wasn't
have
there.
dressed people dressed in funny ways and all that. No, but anyway,
Let's come back to
anyway,
Mr.
let me,
Silvenso.
I think you made a good point. So you accept the fact that I could have done it at 3,000.
You
panel,
obviously
right?
can do it 3,000
So-
as a developer. We can't.
Okay, fair enough. So if we come to some settlement on the 140 that, you guys have looked in a crystal ball and figured it's going to fall anyway, right? If we come to some form of an agreement to take that on, you agree that we'll do it at our cost, our quality. Would that be all right?
Equivalent quality.
Equivalent quality to what we've done.
No, but see, we have no quibble if you want to replace the panels because, as I said,
Okay?
you're the
Okay.
developer,
Okay.
you get the best prices,
Okay.
right? If you replace 140 glass panels, we
Okay.
don't have an issue.
Then give me a minute about the 20, because I understand that you knee-jerk reacted and did the 12.5 or whatever.
Correct. So,
Okay, so-
so you understand what we're sharing with you? Yes, perhaps we could have done it less, right? But we didn't have the luxury of time.
And you were ignoring us. So we were desperate.
We're not going down that path about your quickie and in a day and all of that. Okay, so let's not go down that path.
Round
okay?
rules, Mr. Mediator.
Mr. Building, please
No, we're
contain
almost
your
there. We're almost
comments.
there.
Yes, fine.
Okay, 5 on the 20 panels.
But this requires a global settlement.
5 is, no, you have to understand they are out of pocket. Okay, it may not be a big figure for you, but $250,000 for an MCSD that doesn't have that. After paying paid that doesn't have that kind of money left, that's not something that my chairman can go back and give a good explanation or account to the subsidiary proprietors. I mean, you have to understand that within reason, I'm sure she can sell the answer back to the MCSD, but you're asking for a knockdown of over 70%. You can't do that. You can't do that, right?
Cannot. My sinking fund. I shouldn't have said that.
Why
You just need floats. You just need
why
floats.
don't,
The
why don't
sinking
you
will
tell
go
the
up.
developer your mandate? What are you prepared to accept?
My poor sinking fund might be able to stretch if you bring up that price more. 4,000 definitely cannot. Don't even try 5,000. Try something more.
We went to 5, right? So she doesn't know her maths.
She doesn't.
Okay, it's all right. Okay, I tell you what. Assure me that my main contractor would not face any problems. This is going to be wrapped up in totality
As a global settlement.
as a global settlement. On that 140 other panels, we do it at our cost, and we wrap your 20 panels at 6,000.
What
Final.
sorry, just very quickly, when you say that there's no more troubles with being contractor, are you saying that we must promise not to sue them? Is that what you're saying?
Yes, or us, for anything else.
For my learned friend's benefit, it's a full release and a confidential settlement.
Yeah, I know what a full release is. No, we have one concern. We have one concern. In terms of the replacement, I mean, we're happy to have you do it, but what assurance do we have from you that it will be done properly? I mean, if you are getting the same guys to do it again, it's not going to work, right?
Okay, then why don't we get an expert to come and take a look at it? Because I'm quite sure that the quality of my work is good.
And you pay for the expert?
No, we should share that one.
No, wait, I want to nominate expert. I know an expert. His name is Mr. No Nonsense. I want that one.
Sounds reasonable. If you want us to share, then we should have a right to also appoint one. I mean, we're the one who's concerned with the quality, not you.
Yeah, you know what? The standard of my work is A grade, so whoever you want to pick, it doesn't matter.
Okay, so just so we're clear, so that we can consider the rest of your terms, right? We'll appoint an expert.
Yes.
You're okay with Mr. No Nonsense.
Yes,
He will suggest a method of work.
yes,
Your guys will do it.
yes.
No Nonsense will come back and check on the quality of work and confirm that it's okay.
Who's paying for him?
We'll share it, right?
So you take the dollars and I take the cents.
Half,
We'll
half.
share it equally.
Okay.
Okay. Give us a quick moment. Let's discuss your other terms. What do you mean?
Okay. $6,000 a panel to replace for the 20,
To pay for 20. Yeah.
the 20 panels. $6,000 a panel.
And
How?
what about the tiles? Are you going to drop that? The tiles at the swimming pool?
The tiles you replace, no?
Can you fix it? I mean, look, right now, it's not really a major issue, right? There's some pop tiles, you've got the full extent, you saw the report. Can you fix it?
Yes. As long as she dresses decently, she doesn't make it pop again, we're fine.
And equivalent tiles only, not better
Yes.
tiles.
Done.
Yeah, well, I think we're okay with that.
Okay, so we have a full settlement. I just repeat, you will reimburse the MCSD at $6,000 per panel.
Yes. For the 20.
Yes.
For the 20
And
tiles.
for the 140, you will replace it
At our cost.
and at the same quality.
Yes.
And you also undertake...
Not the 12,500, the quality
No,
that
yeah,
we
yes,
was
right.
at
Right,
initially.
yes. And the swimming pool and other defects, you will undertake it to do yourself.
Yes.
Do we have an agreement?
No more liabilities.
Well, all the other stuff like the release and all that.
Oh, yeah,
Yeah.
that's contractual, yeah.
Sure. All
What?
right.
Give me your hat. I want your hat.
You want to come get it?
Can?
You exchange hats or not?
No, this is mine, but I want that one also.
I'm sorry, can the two of you get a room? So I think we have a deal, and I'd like to quick one ahead. Is that all right with my learned friend, Mr. Court Champion?
Of course, but I'll have to draft the settlement agreement first, and everyone can then check it.
Yeah, why don't we do that?
Why do you do that?
Yes,
Well,
the
they have tea
SMC's
and
computer
coffee.
in the chambers, yes. We'll do that right away. I type faster than you.
I'm happy to let you type.
Okay, thank you. I want to see it.
Right. Clause number 1. Tauke will pay MCST the sum of 120,000 for the cost of replacing the 20 panels that have fallen. This is 20 times $6,000. Upon such payment, the MCST shall have no further or other claims against Tauke conglomerate as well as the main contractor in respect of those panels. Tauke will also undertake at our own expense the replacement of the 140 remaining panels. This will be based on the $3,000 panel quality. And to give you assurance, we will be using a method statement prepared by an independent expert, Mr. No Nonsense, the cost of which shall be shared between Tauke conglomerate and the MCSD equally. Upon the completion of the replacement glass panels as certified by the independent expert, the MCST shall have no further or other claims against Tauke conglomerate or the main contractor in respect of those 140 panels. And last but not least, we will also, out of goodwill, at our own cost, rectify the popping tiles in the swimming pool, and upon completion of that, the MCST will have no further or other claims against Tauke conglomerate or the main contractor in respect of the swimming pool tiles. And each party shall keep the subject matter of this dispute strictly confidential.
You agree?
Is that okay?
That sounds about right.
Okay, you sign on it?
Yes, sir.
Thank you. So that brings a close to the mediation. Thank you. Now, before we go, I'll ask MCS, I'll ask Mediation Center to open the doors.
And we'll give you a good feedback form
Yes.
Yeah.
when you do that.
Yeah. Before we conclude, I would like to always say this. We came here as know each other as acquaintances, but we all live as friends. So I would like everyone to shake on it, and also congratulate you on the successful outcome. All right?
So let me also say, we thank you for your effort and time. I know it's not easy to dealing with two the parties, and I think I speak for everybody to say we're very appreciative. Thank you, sir.
Thank you.
Thank you very much.
Thank you, sir.
Thank you very much.
Yeah.
Thank you.
Share your views. What we're going to do is very simple because this is the tail end. I don't want to take too much time. I'm going to be posing a few statements to each of the panelists, and I would like them to sort of give their view on this statement and share some personal experience relating to it. The statements are related to what are commonly mentioned as advantages or benefits of mediation, why you should mediate, all right? So I would like to start with Justice Lai, if you don't mind. The first statement is it's a very common statement that people say. It says that mediation saves time and cost compared to going to court or arbitration. So what are your thoughts on this?
Well, that's correct, because mediation will be the cheapest form of dispute resolution. You have nothing to lose. You go to mediation first. If it doesn't work, then you go into arbitration. And as a last resort, you go to court. It is. And of course, nobody knows about it because of the confidentiality issue.
Yeah, in your experience, like how long does a mediation take compared to a typical construction dispute in a court setting?
Oh, for construction disputes, I think the mediation sessions have never lasted more than a day, 2 days at most. You go into court on a construction case, depending whether the dispute is on liability or quantum or both, you could be there for a couple of weeks. It's going to cost you a lot of money because of hearing fees, your counsel's fees, and your losing party, you have to pay your own counsel, you have to pay the opposing counsel. So, go to mediation, cheap and fast.
Thank you, Judge. Okay, so for the next statement, I'm going to ask Mr. Koh. Actually, I think you each have a mic. Yeah, no? You don't know? Okay. Yeah, I think you're sitting on the mic. Yeah. Okay, so Mr. Koh, the statement that I would like to comment on is, mediation is confidential. Tell us more. What do you think about this, and in your own personal experience, mediation is confidential?
Okay, so entirely true. You've watched how the mediator starts off by telling both parties whatever is discussed here is strictly confidential, and whatever is conveyed here cannot be communicated outside of this room with third parties or if the matter goes to court. That's helpful because it encourages parties to use this environment and this facility to open their hearts, as it were, to share their grievances as to why this matter has come to a head and we're going to go to court and fight it out unless we try and reach a settlement today. Okay, so that's helpful. My only one reservation is this, and you've watched a very good demonstration of that just now. The conversations that go on in the room should be productive. what is shared should be moving the conversation towards trying to reach a settlement that's certain, that is quick, and that's expedient and efficient instead of going to court, where sometimes it's a bit of a gamble. My reservation is that in this conversation where we are told it's confidential, we sometimes let slip the way you saw Miss Tu did sometimes, and she's, oops, I talked about the sinking fund. So I think we have to be careful in the mediation setting not to share our weaknesses, although we're keeping our hearts open, wearing our hearts on our sleeve, and trying to build a relationship in this room within that one full day to try and reach a settlement in a friendlier, warmer environment rather than in court, which is pretty much sometimes a battle of experts or battle of positions.
Yeah. So why is confidentiality such a big deal? Why is it an advantage compared to, say, fighting out in court?
Because we're trying to achieve an outcome that we know if we achieve it tonight and sign off on the settlement agreement as we've just seen, okay, saves that next 1 year of time that can be spent more productively, right, in your businesses, or for us as lawyers, we move on to another case to try and solve another problem. So in trying to achieve that outcome, where we have a settlement, we need to sometimes share with the opposing party not just our positions, because that's in the court documents. It's not what we want, but what we need. So Cholong talked about interests. To try and find out about each other's interests, we need to find out what the other side needs. And I think that sort of confidentiality is important to invite us to share openly. Then we can find a common solution.
Thanks, Daniel. I actually want to add a point to this, where you notice in the mock mediation, one of the reasons why the developer was even in the room when he actually had a good defense of the independent contractor was that there was a reputational issue at stake. He was concerned that if the contractor was brought to court, that could actually affect the future launches of his other projects because they're related companies. So this is something that mediation provides, where you can actually have all your dirty linen aired in a setting that will not go out to the public. Whereas if you go to court, it's reported, and that could have other kinds of reputational damage. So that's something that we really want to stress about mediation. So thanks, Daniel. Moving to Mr. Chan. This statement, mediation preserves business relationships better than litigation or arbitration. What do you have to say about that?
This statement is absolutely true, because I've always told my clients, especially when you're dealing with management corporations, it's a committee, and and faced with so many problems. Initially, when the report comes out, it usually would be numbering at least 500 defects, not just at 200, which you heard in the mediation. Now, naturally, of course, when this report is submitted to the architects and the project managers, from the outside, the building looks fantastic. In fact, there's a lot of projects today that have won awards and all that. But when the building surveyor goes through the insides of the building, those reports are really very shocking. However, I've always told my clients, if you buy from a reputable developer, do you think they want the names to be smeared with all this, legal suits? So I've always believed that if we take a sensible approach and we submit the report to the top management, they will sit up and look at it. And more often than not, we always manage to settle at mediation, sometimes even without going to mediation centers. But if sometimes, perhaps maybe at the last minute, they had to do a protective writ, then of course going to the mediation center would be the best choice. And I have experienced that mediation has always been the best way. As the lawyer says, sometimes I tell my clients, take a haircut. Because if you don't, you end up, maybe worrying about whether you will win the case. And as the judge has said, if you lose, then you pay double fees for both sides. So in that situation, if you less all those risks and costs that you incur, mediation is always better. And it also develops a good relationship, because after the developer has settled at mediation, don't forget, they're still your potential customers for your next job. I've heard a very acrimonious situation where one of my chairmen says, I will never buy another unit from that developer. So that I don't think is what developers want to have.
Mr. Chan, in your experience, have you seen parties who have gone for a court case end up having such a bad relationship that they don't want to work with each other again? I mean, have you seen this kind of thing happen before?
Actually, going to court gives you butterflies in the stomach. I've seen my clients right at the doorstep of the court, and you know, they start worrying and they start asking, you know, should we settle? And I myself, even as a witness, I get butterflies in my stomach. So I dare say that so far we've never gone for a full trial in any situation. The worst case was when we had to settle right the day, you know, at the mediation center, and they finally agreed, even without going to the court. So I believe that it works all the time.
Right, thank you. Mr. Lim, can you comment on this statement? Mediation allows you to choose who your neutral is.
Right. So I guess before I start on that, I think where I wanted to come off for mediation itself is, I guess as a business, for us, it was a matter of understanding you have multiple tools at your disposal. Mediation is one of them. So why would you want to choose this tool? Well, fundamentally, mediation, the experience that I had was very different. You're not looking at a winner-loser situation. Mediation, in a way, fundamentally, you're talking about a situation whereby you come to a settlement, you come to a position where both parties can walk away. In a sense, there's no loser. So with that respect, one interesting thing with mediation was that you are able to choose, in a sense, a neutral party, and more than just a neutral party, as what Julian was saying, that depending on the subject matter, I guess mediation allows you to choose a mediator who has specific domain knowledge. And what I guess trying to say about that is a mediator with a specific knowledge in a certain field with regards to the subject matter that's being discussed between parties. That may actually help to bring parties closer because that mediator would have the specific knowledge.
Let me play the devil's advocate here. Why don't I just go to court anyway and just have the judge be advised by expert witnesses? Isn't that the same thing?
Well, I guess you can do that. You know, the point about going to court would then be that you never know the outcome. You can never control what would happen. You'll be pitting, I guess, when talking about court situation, expert witnesses on both parties against each other. And you'll be, I would say that when you're in that situation, again, you will never know who would win, who would lose. So parties would always have to make a judgment for themselves. I guess, again, that's the whole idea of mediation. You do have this tool whereby you have full control, I think as what Judge was mentioning. It allows you to decide the outcome. If you're really, really not happy with the outcome, you walk away. But then the beauty of mediation is that if you do have the outcome that both parties can agree on, both parties can then be reasonably satisfied.
So I just want to check, in your experience, have you encountered situations where you had a dispute and you felt that it would be useful for someone in the room to sort of be like a peacemaker or, you know, a voice of reason when both sides are getting very heated? Have you experienced anything like that before?
Well, in a way, yes. I guess to put that in perspective, it's more of when you have parties who are maybe entrenched in their positions. It may be helpful just to have a neutral party to say, calm down, you know, let's reassess. And so with that, it's always a matter of assessing perhaps when is a good time for even adopting the stance of mediation. I think as Mr. Chan was saying, you're talking about people are saying doing mediation early because that may help to preserve relationships. There could also be a point, as Mr. Chan has also said, certain cases, some details have to be fleshed out further, you know, before mediation actually has a possibility to take fruit. And then, which brings me down to your question, yes, it all depends on, I guess, the mediator to be able to bring parties to say, you know, let's reassess.
Actually, I just want to touch on that a bit more with Mr. Koh. Can I just ask, in your experience, have you seen situations where a neutral, a mediator, actually helped to do some kind of reality checking that was very useful in a setting where both sides were totally convinced that they were correct, and it needed somebody else to come and sort of help them to realize that maybe their positions are a bit extreme? Did you find any of that in your own experience?
Yes, I have. I'd start first by saying that it's important for the mediator to have credibility, not just from his credentials and having the domain knowledge that Mr. Lim talked about. It's also that after a couple of hours into the morning, there needs to be a certain trust that's established between the parties and the mediator, so that when the mediator sits down with the parties in in the private settings, the mediator can then tell the parties, I think your rectification method statement is somewhat too extravagant. It can be done for cheaper by using these methods. And the mediator, perhaps from his experience either as an engineer or as a building surveyor or someone else in the trade, is able to comment and give his thoughts about it. So that's the reality check that's helpful, and then that sort of brings the claiming party a bit more, it helps the claiming party be a little bit more rational and be reasonable in adopting perhaps a lesser, more reasonable method of rectifying the defects.
Okay, and then I would just like to put this question to Justice Lai. As a judge, you are expected to make a decision in a case. But as a mediator, you're supposed to facilitate the parties reaching their own settlement. But yet, sometimes you feel that one or both sides are being unreasonable and not being in touch with reality. So how do you personally try to guide them along without actually reverting to being a judge in a mediation?
Yeah, there's a fine line. You have to be very careful. A mediator is not a judge, and the judge shouldn't be a mediator. In my case, I think I have an advantage because of my years of experience on the bench. I suppose I have a bit more credibility or respect. So sometimes when the parties are being unreasonable, I will tell them, say, in this instance, do you mind if I put on my hat as a judge? And I'm looking at it very objectively. If you were appearing in my court, and this is what I see, then I would tell them, this is the position. And I think a common example would be, I've had the cases before where a neighbor causes damage to his adjoining neighbor's property. The aggrieved party, the next door neighbor, then comes along. But he comes with very unreasonable demands, and he actually wants new for all. You know, a whole string of rectification works. And I had to say to this particular claimant, I said, look, you go into court, no judge is going to give you new for all. You want 100,000 for this item, but your house has been standing there for 40 years. Wear and tear. You can't get that. You're not going to get 100,000. You may get probably 10% of it. He may not like it, but sometimes I have to be very firm. I say, look, if you do go into court, this is the position. It's a sort of reality check. But I cannot go beyond my boundaries. I can just say, look, this is how it may probably happen, all right? And the other thing I employ is that, look, mediators, as Mr. Lim has explained, you are able to choose somebody from the domain, somebody who's an experienced or an expert in that particular area of dispute. Judges are human. Judges cannot be know-alls. We try in the courts here to give especially judges for certain specialist disputes. If at an IP, intellectual property, we try and find intellectual property judge or you. But we have a lot of cases. Sometimes a particular judge who is particularly familiar, experienced, or an expert in a particular field is not available. That goes for construction disputes as well. So you may have a judge who's not so familiar. He may then, for want of a better alternative, fall upon the experts. More often than not, you do have experts in construction cases. And as everybody in this room knows, no two experts ever agree. So you're going to have two conflicting opinions, and it's very difficult. The judge has to make up his mind. Of course, he cannot accept either one, but that's not likely to happen because he's not in a better position to know better than the two experts. So it's very much it's a lot of element of unpredictability, all right? If your opponent who loses has deeper pockets, he goes to the Court of Appeal. So you have 3, 4 wise persons. Nobody is infallible as well. So you may not win in the Court of Appeal. If you lose in the first round, you still lose in the second round. There's a lot of the element of uncertainty, which you can control very much more, which is very much within your control when you go for mediation. In mediation, you can control the outcome, you can control your own destiny. You go into court, is a lot of unpredictability, a lot of depending hot luck, so to speak.
Thank you, Judge. So can I just summarize regarding this point about reality testing, that one of the advantages of the mediator injecting that dose of reality is that it sometimes makes parties who entered the room thinking that they don't need to settle because they have such a strong position, it changes their mind and causes them to realize that maybe my position isn't as strong as I thought and I ought to be open to the offer from the other side. Have you seen that happen in a mediation? Where parties sort of become more amenable to talking when you've sort of helped them understand that what they're asking for initially or their initial positions are unreasonable or extreme. Have you seen that before?
Oh yes, quite often. Mediation can be a reality check, and it's best that the reality check comes at the stage of mediation than for you to go back to court, because well, more often than not, there's a case pending in the courts, and the parties then decide to go to mediation to try and resolve it amicably. So it's a very good reality check in most cases.
Thank you. Mr. Chan, I want to ask, what are your thoughts on this statement? Better to have a mediated settlement now than a paper judgment later on?
Now that is always on the minds of my clients, because I've always told them that you might win the case, but then the judge will never award you 100% of what you ask for. So if they award you 70%, and then if you less your cost and so on, you might find that at the end of the day, you end up with a paper judgment. So it's always, the best prerogative is always to see the dollar value, less whatever your expenses would be, and make sure that at the end of the day, you walk away with sufficient money in your pocket. Yeah, if you're fighting on principle alone, at the end of the day, I think it would just be a paper judgment, as in your cost is equal to your, whatever the judge awards you. So this is one of the issues. But of course, of late, what is, established, as we all now know, about the independent contractors' defense, I've always had to tell my clients, take a reality check, okay? If we go that way, chances are you may not win in dollar value. But surely with a mediation and a settlement, I think we're much better off. So look out. Yeah? Don't go for paper judgment just because you're angry. Yeah? And it's always better to go to settle at mediation.
Thank you. On this issue of paper judgment, I would like to ask all four panelists, have any of you encountered a situation where at the point where a court action was initiated, you thought that you could get money from the other side, but by the time you won the case, the other side actually went bankrupt or insolvent, and even though you have a judgment in hand, there's no money to be had. Any of you had encountered this kind of situation before? You're nodding.
Yes, and that's when we insolvency lawyers we insolvency lawyers have a separate scope of work to be performed. I think Mr. Chan is correct, but I think the truth also is this. It's quite common that in a mediation setting, when we're in mediation, you saw a demonstration just now where it was just a developer being sued or potentially being sued. In real life, an MCST would probably join in as other parties to be sued, what we call other defendants, the main con, the specialist subcon, for whichever trades that's in question. And sometimes, and I've certainly encountered cases, I'm sure my lawyer friends in the room have also encountered situations where we bring court proceedings against all these different defendants, and the subcons don't even turn up because a couple of them may have really gone bust. So, so I think Mr. Chan's point is correct. My caveat is that I think when there's an MCST bringing a claim, they know that that is a problem, but the main con and developers, they can't make the problem go away if they offer something that is so insulting or derisory. So I think everybody needs to try and find a solution if they really want to make it work.
And since Mr. Koh has been talking, can I ask you to comment on this statement? Mediation can result in creative solutions that can't be found in a court or in arbitration.
That clearly is one of the benefits of mediation, because as the judge says, you're the masters of your own destiny. You can create a solution today to solve the problem. If we're in court, it's just about damages. It's just about monetary compensation, right? And the paper judgment is meaningless. It's that paper tiger that Mr. Chan is correct in pointing out. So, just 3 quick illustrations. One, maybe that subcon, that specialist glass subcon is it's a $2 company, it's worthless. The main con developer here has an interest that they want to protect. Maybe an idea is to have an agreement to extend a warranty. So maybe the 10 years specialist waterproofing works warranty has really expired. Can the main con consider perhaps giving a goodwill extension of a warranty? So that's one way of resolving the problem. And addresses the MCST's concerns and needs, right? Second quick way is, in a real life situation in mediation, the expert witnesses are quite often welcome. So the MCST would have their building survey expert, the developer may have theirs as well. So in the course of the mediation, by 4 p.m. or so, if parties generally can agree on a way to rectify the defects, then the experts can chip in together with the mediator who has domain knowledge, very helpful, draft out a agreed rectification method statement. So that too is another option to explore, which you can't get from a judge in court. Finally, very quickly, and it really depends. I've encountered situations, and it's context specific, right? Not every project works out this way. It just so happened that the developer had, and with its related main con, had some spare cooker hood hop systems. And they offered this to the subsidiary proprietors, and they were quite happy to take that as a sweet and icing on the cake as part of the settlement package. No skin off their nose because they had some ready spare stocks, and the subsidiary proprietors, well, if it's free, why not? Right? So that's nice to have. Talking about reputation, conversely, I mean, well, developers, of course, have a reputation that they want to protect. We sometimes tell the MCSTs or even claimants or even house owners that, look, you don't want your case publicized as well, because if it's well reported that this project is crummy or your house is badly built, how are you going to resell your unit next time? Not good for you either, And so everyone realizes they've got their own interests to sort of protect and look out for, so better to try and resolve it here today.
How about the rest? Any of you encountered interesting solutions that came out from mediation? Things that you found that you were never gotten in a court?
Well, maybe not so much an interesting solution, but one of the things that I was really considering, and I think has shown again in the mock session, it is very rarely as a business where you have the chance to employ a tool, in this case to solve a dispute, and yet not worry about the tool having any negative effects. So I think in businesses we talk about having a potential of going to disputes or risks of that. But yet, mediation was one example whereby, yeah, you can choose to employ it, and if it doesn't work out, it doesn't work out. Because it's not going to work out for 100% of the cases. But that's where you always have that so-called base position where you will not suffer that much of a blowback, even if it does not succeed.
It's very interesting what Mr. Lim talked about as a tool, because the interesting thing about mediation is that it doesn't preclude you from exploring other options later. That means it doesn't mean that you've gone for mediation, you can't go to court, or you can't go for arbitration. All your options remain on the table. And on top of it, mediation is a low-cost solution. It's usually a day. I think mediators here will agree that most disputes get resolved in a day, or by the end of the day, you know that it won't be resolved. So there's no point having a second or third day. That's usually not helpful. So in a way, you're sort of spending one day to see whether you can avoid 2 weeks in court. And I think that's a trade-off that seems to be worth trying. And I'll just add one of my stories into the creative solution mix, where we've had a story of parties who came to court because of a debt. One party claimed that the other side owed a debt, and the other side didn't want to pay. Now, during the mediation, it transpired that the party that owed the money did not dispute the debt. They were agreeable that we have to pay this. But the problem was that they had trouble raising money to pay the debt, and that's why they got sued. And as the mediation went out, it basically came to light that the party that was trying to raise the money was trying to sell some equipment to raise money to pay the debt. But there was no ready market for that equipment in their home country, so no one was buying it, they couldn't raise the money. But because they mentioned it in the mediation, the other side realized that, hey, that equipment is actually valuable in my country. There is a ready market for that equipment. So how about if you transfer the equipment to me and I sell it, we'll call it square. We can write off the debt. And that's how the mediation settled. So that's a very unique situation because you cannot get that in a court. That piece of equipment wasn't even part of the dispute. But in the end, both sides were happy. So this is an example of what a creative solution could look like in a mediation. Because mediation is about problem solving, not blame apportioning. So, okay, so I'm conscious that we are running to the end of the time. I would like just to ask the panelists, do you have any final thoughts, anything you just want to add about mediation in general and why it's a very good dispute resolution tool that people should consider, especially before going to court and arbitration?
I have one experience, and somehow or other, when I enter that mediation with my clients, I find that the mediators are so angelic, for lack of a better word. They take away all that, that anxiety, that anger, and that frustration. And somehow they seem to be able to reach out to you and say, look, we know you are angry 1 year ago, that's why you started the action, and that was why you had to do it. But today, there is a solution, and it's as though somebody has just come down from heaven and say, look, I'm your peacemaker. And it works almost all the time. And I really am grateful to these mediators that we have.
Thank you, Mr. Chan. And anyone else to add?
Amen to that.
I would say that judges also can be angelic, not just mediators. But I think what's important is if we have to go to court, if we really have to go to court to fight, then by the time we go to trial and we've gone through that, I mean, for us lawyers, it's intellectually stimulating, the legal issues, the case to work on, the witnesses that we work with. But it's very stressful for the parties, the litigants, the laypersons, the companies. I mean, of course, you're better off making money and doing business productively outside of preparing for a court case. But if you have no choice but to go to court and do a trial, having first referred to mediation, you know that at least you've tried. So you really should at least give it a try. And if you can't reach settlement, at least you have tried. So that when you go to court, you know you have already tried. So no choice, we now have to go to trial.
Oh, actually, sorry, I just remember one point arising out of Mr. Koh's comment. I've also heard of cases where parties went for mediation, they could not get a full settlement of all the issues in dispute. But the mediation actually brought them a lot closer because they understand each other's positions better, so that when they finally went to court, they actually only litigated over one small issue that they couldn't resolve. And maybe sometimes it's because there's a point of law that they need resolved by a judge. But the dispute went from a very big, complicated lawsuit into actually quite a straightforward case, and the rest was settled. So I think that's another advantage of mediation. You may bring parties closer together before the court case even starts. So anyway, can I just round up what we talked about at this panel before we end? We just want to remind you that the things that we covered is that mediation has several advantages. I'll start off by saying that it's a way that you can save time and cost. If you reach a settlement, you can avoid a very long and expensive process in the courts or in arbitration. Mediation gives you control over the outcome. You can walk away. If you don't like the settlement that's before you, if you don't like the way the other side is offering, you can say, look, I can't accept this, and you can go. No one's going to compel you to take it. Mediation is confidential. It's in a setting where it's not reported, it's not public, so whatever wrongs or things that was not done properly by your side doesn't cause you reputational damage out there. Next, mediation can result in creative solutions, as we talked about, ways to resolve a dispute that you'll not get from a court. Mediation preserves business relationships. The aim of mediation is to try to have parties happy with the outcome. It's not necessarily the perfect outcome that you wanted, but it's an acceptable outcome that you're prepared to walk away with. And the aim will be that after that, you can leave the room and still do business with one another, which I think is very important in certain industries where you don't really have that many people that you want to work with. The next one is that it's better to have a mediated settlement in hand than a paper judgment down the road. And as was pointed out, you may end up paying so much in cost to your lawyers that you don't really have much at the end with the judgment, or your opposing side may actually be insolvent by then and you get nothing anyway. Then we said that mediation allows you to choose who your neutral is. Sometimes it's very important to have a knowledgeable neutral because a judge, as good as they are generalists. They have to understand everything, but they don't have the depth of specialist knowledge that is required in certain scenarios. So having the ability to choose a neutral is very helpful in that case. So I hope that through both the mock mediation and the panel, all of you who have come tonight have a better idea of firstly what mediation is, how the process works, and secondly, why mediation is so effective that we actually have a settlement rate of 70%. Which, if you stop and think about it, for a one-day session where you just talk to the other side, 70% of the parties walk away with a settlement. And that settlement number is actually higher if you include the people who come to an agreement outside of the mediation. There are many cases, they don't settle on that night itself, sometimes because they're so tired, or sometimes because they want to go back and think about the offer that was laid in front of them. But we frequently hear that several days later, they sign. So I think there's something that everyone should take seriously about all these benefits of mediation. And so, thank you so much for coming. I want to just thank you all for making the time to come.